Hello, I am Brian from Seoul Law Group, and we are an English-speaking law firm based in Seoul, South Korea. We're back with another law video, and today we'll cover child support in Korea. When you get divorced with having a child or children to raise, one shall have custody over the child, and the other shall pay a portion for the cost of raising a child. This payment is called child support. So how much should child support be? The major criteria for the decision are the age of the child and the total income of the parents. The philosophy of Korean family law is to guarantee an equivalent level of living to the child after the divorce, as the child should be affected by the divorce as little as possible. Moreover, it is expected that the expenditure, for example, education fees for hagwons, shall rise as the child grows older. And therefore, the basic standards of child support is decided by such criteria. According to the table of standards, child supports could range from at least 621,000 Korean won to at most 2,883,000 Korean won. The actual child support is decided based on the table, but it is adjusted with consideration of all other situations. Can child support be changed or raised? The simple answer is yes. Even if the child support is once decided by the court or by mutual agreement, it still can be changed after the original decision or agreement. This is quite unique and exceptional from the perspective of legal minds, because once the deal is sealed, you cannot change the deal. This is the most basic philosophy of a contract or an agreement. Moreover, in case of a judgment by the court, once it becomes final and conclusive, you cannot overrule the finalized judgment. That is the basic philosophy for the final judgment. However, the philosophy of Korean family law is to prioritize the welfare of a child. If there are certain reasons that may affect the welfare of the child, even the finalized child support or the mutual agreement must be overruled. It is stipulated in the Civil Act, Article 837, Paragraph 5. In addition, the Supreme Court Decision 2018 Su 566 decided on January 31, 2019, that child support falls under the clause matters concerning fostering. Therefore, by Article 837, Paragraph 5, the child support could be changed when the decisions of the family court or the agreement between each party is inappropriate for the child's welfare. Therefore, when it is required for the welfare of the child, then you may ask for the change of the child support to the family court. The family court then shall decide the appropriate child support for your case. Change of child support. What could be the reason for the change? As previously explained, the amount of child support is decided based on the age of the child and the total income of the parents. In addition, the assets of the parents, that you may still be wealthy without an income if you already have accumulated a large amount of money, the place of the child living, or special medical expenditures due to certain disorders or diathesis. Seoul Law Group has dealt with various divorce and child support cases. Among them, we are proud to introduce this case we dealt with. In this case, the initial child support written in the divorce report was only 300,000 Korean won per month, which is even below the minimum level of child support. To change the child support, the client came to us. We began filing a petition to change the child support, and the result was satisfying. The amount of child support raised from 300,000 Korean won to 1.2 million Korean won per month. The child support had quadrupled. To raise a child alone, you need money. If you had mistakenly made an agreement of unfair child support, do not panic, but ask for legal help. Seoul Law Group has various experiences with divorce, custody, and child support. If you have any problems, please do not hesitate to contact us. Don't forget to like, subscribe to our channel, and turn on the notification bell for more Korean law videos, and we hope to see you next time. Goodbye.